Welcome everyone. We're glad you could join us today for our brief on the latest with the graphic warning labels lawsuit, RJ Reynolds versus FDA. My name is Esther Agbaje, and I'm a senior staff attorney at PHLC. And today our team will discuss the case and the status of the graphic warning labels for combustible cigarettes. The Public Health Law Center is located at Mitchell-Hamlin School of Law in St. Paul, Minnesota. The center helps local, state, national, tribal, and global leaders promote health by strengthening public policies. For over 20 years, the center has fought to regulate and eliminate commercial tobacco products, increase access to healthy food, support physical activity, promote equitable transportation, and improve environmental health as a means of reducing chronic disease. When we talk about regulating tobacco, we are discussing industrial-scale commercial tobacco products, not traditional tobacco, which we know is used either religiously, medicinally, or in the ceremonies of many different cultures and tribal traditions. In our work, we understand that many of the public health issues we address are because of the social determinants of health. Under this framework, we understand that all aspects of our lives influence our health, from our economic situation, the physical environment in which we live, our access to education, the food we eat, the community we live in and its social fabric, to the healthcare available to us. And depending on your social status, you could be set up to systemically have better or worse health outcomes. So from this knowledge, the center is focused on pursuing health equity through federal regulations, as well as state, local, and tribal policies and laws. When we're discussing equity from the perspective of public health, we're looking to ensure that everyone has the appropriate access to the resources and support to live healthier lives. Similar to this slide, you can see that everyone has what they need to cross the street. Our work is meant to ensure that the laws and regulations that come from the federal government have a focus on helping those who have been most directly targeted and affected by the harms of the tobacco industry. We consider it our responsibility to use our legal knowledge to bring justice to public health, as we support our partners in reducing health disparities. And finally, the Public Health Law Center does offer free legal technical assistance to communities, public health advocates, and other partners. So if you find yourself in need of support, definitely feel free to reach out to us. But we do not offer direct legal representation, nor do we lobby. And now that you understand a little bit more about us, I will turn it over to my colleague, Luke, who can walk us through the latest case on graphic warning labels.
Thanks, Esther. As Esther noted, I'm going to give us a brief background on cigarette warning labels before Tom delves deeper into some recent cases. Dating back to the Surgeon General's warnings and the Federal Cigarette Labeling and Advertising Act, the federal government has regulated warning labels on tobacco products for more than half a century. The original statement was caution: cigarette smoking may be hazardous to your health. The Public Health Smoking Act of 1969 updated this statement to read, warning: the Surgeon General has determined that cigarette smoking is dangerous to your health. In 1984, the Comprehensive Smoking and Education Act amended the Federal Cigarette Labeling and Advertising Act to require one of 4 possible messages about the health risks of smoking, warnings that are still used today. This amendment also extended the warning requirement to cigarette advertisements, not just cigarette packaging. Implementing these warnings wasn't always the responsibility of the FDA. The FDA had attempted to regulate cigarettes as drugs or devices in the late 1990s, but the Supreme Court ruled in FDA v. Brown and Williamson in 2000 that the Food, Drug, and Cosmetic Act did not give the agency the authority to regulate tobacco products. In 2009, the Family Smoking Prevention and Tobacco Control Act gave the FDA authority over many tobacco products, including a mandate that it require new graphic warning labels. The Tobacco Control Act requires the FDA to establish a rule requiring tobacco manufacturers to place warning labels that cover 50% of the surface of the front and rear of cigarette packages, as well as warning labels covering 20% of the area of cigarette advertisements. The Act also requires the FDA to issue regulations requiring the warning text to be accompanied by colored graphics that depict the negative health consequences of smoking. The FDA released the final rule governing the new graphic warnings in June of 2011 and scheduled the regulation to take effect in September of 2012. In 2011, however, several tobacco manufacturers filed suit against the FDA to challenge the agency's graphic warnings rule. One of these lawsuits, R.J. Reynolds v. FDA, targeted the specific regulation that the FDA issued, while the second, Discount Tobacco City and Lottery v. United States, challenged Congress's authority to require such warnings in the Tobacco Control Act. In the case in which the industry challenged the constitutionality of the Tobacco Control Act, the district court upheld the Act's graphic warnings requirement, and the Sixth Circuit affirmed. In the case challenging the FDA's specific regulation, however, the district court found that the particular graphic warnings rule it issued violated the plaintiff's rights under the First Amendment, and the D.C. Circuit affirmed. The FDA consequently announced its plans to develop and propose a new graphic warnings rule. The FDA did not issue a proposed rule, however, until it was sued by public health groups in 2016 and required to do so by a court order. The new version of the graphic warnings rule was issued in March of 2020, and it was again subject to industry-led litigation. I'll now turn it over to Tom to dig deeper into this First Amendment jurisprudence, including the industry's most recent attempt to prevent the FDA from carrying out its mandate to require graphic warnings.
Thanks very much. My name is Tom Pryor. I am a staff attorney here at the Public Health Law Center, and I'm going to be covering First Amendment jurisprudence on commercial speech cases before diving specifically into the R.J. Reynolds v. FDA case. And then I'm going to wrap up with some very brief takeaways that folks can consider going forward. So with that, let's look specifically at the First Amendment and the text itself, which says, relevant to this conversation, Congress shall make no law abridging the freedom of speech. So the First Amendment broadly protects speech, which includes things like verbal speech, but also written speech and expressive conduct. The First Amendment's protections are expansive, covering everything from speaking at political rallies or wearing protest armbands to discussing the weather or blogging about TV shows. And it includes protecting commercial speech or speech that proposes an economic transaction with things like marketing or advertising. Now, that being said, commercial speech is not protected at the same level as core speech like political advocacy, and that's because it takes place in an arena that's already heavily regulated. But it does receive First Amendment protection because, as the courts have noted, commercial speech can convey truthful and useful information, and it can advance discussions in the marketplace of ideas, and it can certainly be helpful to consumers. With that in mind, let's look at levels of judicial scrutiny. Now, courts will often use tests or rules when they tackle legal questions, and in the realm of constitutional questions, they often apply a framework like strict scrutiny or rational basis review that essentially determines how skeptical they'll be that a law is constitutional. You can think of it as being like a logic-based hurdle, with a more exacting test presenting a higher hurdle for the government to clear if it wants to prove that its law is constitutional. The three most commonly used levels of scrutiny are listed here: strict scrutiny, intermediate scrutiny, and rational basis review. You can think of these levels of scrutiny as existing along a continuum, with the most rigorous being strict scrutiny. If a law triggers strict scrutiny, the government will bear the burden of proving that its actual purpose in passing the law was compelling and that it chose the least restrictive means of achieving that purpose. Strict scrutiny is often called strict in theory, fatal in fact, because it's so difficult to meet those requirements. Now, on the other end of the spectrum is rational basis review, which is a very low hurdle to clear. If a law triggers only rational basis review, it must only be rationally related to a legitimate goal, and really any conceivable goal, even one that was cooked up by lawyers after the fact, is enough. Intermediate scrutiny sits somewhere in between those two, and that the government's actual purpose must be important, and the means must be substantially related to achieving that purpose. In practice, there's probably a lot of legal wiggle room here in how strict or lenient a court can be within this intermediate zone. So if a law gets strict scrutiny, you can bet it will probably be struck down. And if it gets rational basis, the smart money is that the law will be upheld. But with intermediate scrutiny, it's much more difficult to tell what will happen. These basic levels of scrutiny are used in multiple areas of constitutional law, and as I mentioned, you can think of them as sitting along a continuum. Now, there are also some First Amendment specific tests the court will use when a challenger is arguing that a law has violated their free speech rights. And you can think about these tests as existing along the same continuum from the most to least rigorous. I'm going to talk about two of those First Amendment tests today because they're the ones that are most relevant to our graphic warning discussion. And we can begin with what's known as the Central Hudson test, which is named after the case from which it originates. This test would apply to any situation in which you're restricting commercial speech, like a law banning retailers from displaying tobacco ads in their windows. Now, normally, a law curtailing someone's ability to post a sign on their property would probably get strict scrutiny, but as I mentioned, commercial speech is not protected to the same level as other forms of speech, so it would get Central Hudson scrutiny instead. And while the Central Hudson test is exacting, it's not quite as demanding as strict scrutiny. If a law triggers Central Hudson scrutiny, the court will ask whether the law is actually restricting protected speech, if the law is justified by a substantial government interest, if the law directly advances that governmental interest, and if there's a reasonable fit between the goal and the means chosen to accomplish that goal. So you can see elements of intermediate and strict scrutiny here. The interest need only be substantial, not compelling, but the means should directly advance the government's interests. In practice, these last two prongs are often the most difficult to satisfy. The public health laws aimed at restricting tobacco advertising are justified by a substantial government interest, public health. What's more difficult, though, is proving that a law restricting speech directly advances that goal and that there are not other means of achieving it that would have a better fit. Central Hudson is more of an art than a science, and sometimes when tackling these last two questions, the court will apply an analysis that looks more like strict scrutiny than anything else. So if, for example, a jurisdiction wanted to eliminate tobacco advertising within certain proximity of schools with the goal of reducing youth rates, the court might require a great deal of evidence to prove that the restriction will achieve that purpose and that other means will intrude upon speech less would not be preferable. The other form of scrutiny I'll talk about today is Zouderer scrutiny, which is, as you can see here, much more lenient than Central Hudson. This would be used when the government requires a speaker to carry an extra disclaimer, disclosure, or warning. Such laws don't limit speech, they actually require more of it, and for that reason, courts are often more willing to permit mandatory disclosure laws than laws that ban or restrict speech altogether. The court applying Zouderer scrutiny will ask if the disclosure requirement is purely factual, accurate, and uncontroversial, if it's reasonably related to a legitimate government interest, or if it's unjustified or unduly burdensome. Now, preventing deception is one, and according to the tobacco industry at least, the only government interest that qualifies for this lower level of scrutiny. So some litigants will argue that it's not enough to simply provide useful and accurate information through these disclosures. The disclosure requirement should correct some inaccuracy or common misunderstanding about the product or service. As we'll see in a bit, however, there's an open debate over whether other government interests can justify a compelled disclosure. The disclosure should also be purely factual and uncontroversial, and these two elements together explain why Zouderer is a lower form of scrutiny than other tests. Speakers don't have as much of a First Amendment interest in omitting accurate disclosures that correct deceptive communications. But this first prong is also an easy stumbling block for governments. If a compelled disclosure is too forceful, for example, it might fail this prong because it's no longer uncontroversial. Similarly, if a compelled disclosure takes a side in a live and controversial public debate, it might be deemed too controversial as well. Or if the disclosure is not falsifiable, it might be deemed an opinion rather than a fact. The point being, governments have to be careful in how they craft these disclosures to ensure that they meet this requirement. Now, there are other forms of scrutiny for First Amendment tests, like the time, place, and manner test that courts apply to conduct-based regulations that incidentally burden expressive activity. But for the purposes of today's discussion, these two are the most relevant ones, because obviously what we're here to talk about are the new graphic warning requirements from the FDA. Now, as Luke explained, these warnings have been challenged on First Amendment grounds. And the question is, what test would you apply to these warnings, and under the relevant test, whether they violate industry's free speech rights? Right off the bat, I'll tell you that the two tests it really comes down to are the Zouderer and Central Hudson tests that we've already discussed. And these are certainly compelled disclosures, which puts you into Zouderer territory, but industry's argument, at least, is that they don't meet Zouderer's requirements, and so you would have to default to Central Hudson scrutiny, and under that more exacting test, the warnings are unconstitutional. Those were the issues at play in R.J. Reynolds v. FDA, a 2024 case resolved at the Fifth Circuit Court of Appeals. That was an appeal from a district court opinion in which the district court actually sided with industry, ruling that the graphic warnings failed Zouderer's scrutiny, and under Central Hudson, they were deemed unconstitutional. The FDA appealed that ruling and prevailed on appeal. Now, this case could go to the Supreme Court, which could change everything, and other circuits could certainly weigh in on this issue and disagree with the Fifth Circuit. But I'll note that the Fifth Circuit is one of the more conservative circuits in the nation, so there's cautious optimism that this might be the prevailing rule going forward. I'll summarize the opinion at a high level, but generally it tackled these major questions, which we'll go through one by one. And remember, if the warnings don't qualify for and satisfy Zouderer's scrutiny, the court would default to Central Hudson scrutiny, which is that more exacting standard, and there would be very good reason to suppose it would fail under that test. The first question the court tackled is whether the warnings were purely factual and uncontroversial. Now, the industry's argument here was that the warnings exaggerate the health risks of smoking, and that the images could be misinterpreted by consumers, and that in any event, they couldn't be considered purely factual and certainly not uncontroversial, given that they were likely to evoke strong emotional responses or even shock from users. The Fifth Circuit, however, disagreed and ruled that the warnings were purely factual and uncontroversial. The written statements were clinically accurate, as were the illustrations. Now, to be sure, those statements and illustrations may evoke emotional responses, but facts can do that. A statement or illustration does not become inaccurate or controversial simply because it's upsetting. So if there's something factually inaccurate about the statements or the illustrations, and there are no live or contentious debates about the health effects of smoking, the industry's argument essentially boils down to an insistence that they don't like the warnings, and that's simply not enough for them to be deemed controversial or inaccurate. The next question is whether the warnings advance legitimate governmental interest. And here, the industry's argument was that the only interest that the government is allowed to pursue when it compels a disclosure is the goal of preventing deception of consumers. And that's taken from the Zouderer case, in which the Supreme Court concluded that preventing consumer deception was indeed a legitimate interest that justified the compelled disclosure at issue in that case. Here, however, the industry argument goes, the warnings are not crafted to prevent deception. They go beyond that and provide more freewheeling health information instead. Again, however, the Fifth Circuit disagreed with industry and ruled that the informational interests advanced by the warnings were legitimate and sufficient. Now, this portion of the opinion parsed a lot of case precedent, but suffice to say that the Fifth Circuit recognized a growing consensus among the appellate courts that anti-deception interests are only one of many legitimate state interests that can justify a compelled disclosure. It went on to conclude that the public health interests advanced by the graphic warnings were sufficient to satisfy the Zouderer standard, especially when one takes into consideration the historical consequences of deception in the tobacco industry's marketing practices. Finally, the court tackled the question of whether the disclosures were unduly burdensome. And here, industry argued that the size and the emotionally laden content of the warnings imposed an undue burden on the industry. And they lost on that point as well. The court was unconcerned about the size of the warning, noting that the warnings only take up 50% of the packaging and that they have only a minimal interest in refusing to carry accurate and useful warnings on their packages. Now, certainly the warnings impose a burden, but that burden is not undue. So to summarize, the Fifth Circuit rejected industry's challenge to the graphic warnings and ruled that under Zouderer, the warnings were justified and did not unduly burden industry's commercial speech rights. Before I move on, I'll also point out that industry had petitioned for an en banc review of this opinion, which means they asked the entire Fifth Circuit Court of Appeals to weigh in on this case, and the Fifth Circuit rejected that review. So the next step in this litigation, if it goes anywhere, would be the Supreme Court. And the Supreme Court would have a choice of whether they accept a petition if it's filed or rejected. And as I mentioned, this is just one circuit opinion, and others could disagree with the Fifth Circuit. And certainly the Supreme Court could weigh in as well and change all of this. But provisionally speaking, if we take this opinion as guidance for how to approach this issue in the future, here are some of the key takeaways as I see them from the opinion. And the first is that illustrations are not inherently inaccurate or controversial. Government can require graphic warning labels, and there's no hard and fast constitutional rule prohibiting them. Now, that being said, drafters should proceed with caution. So I'm a lawyer and I deal in words, and probably some graphic designers and artists might disagree with me here, but I think there's a fair argument to say that pictures are probably more likely to be misinterpreted than words. Pictures can be highly evocative and carry a lot of emotional content. Indeed, that's the point of crafting graphic warnings in the first place. So to abuse a saying, pictures are worth 1,000 words, but you don't necessarily get to pick each of them, with the upshot being that a viewer could more easily misinterpret the meaning behind a picture than they could a paragraph of text. Which is all to say that you can use images in warnings, but you have to be very careful in how you craft them to ensure that they're purely factual and uncontroversial. The second takeaway is that upsetting facts are still facts. A warning or a disclosure about health risks does not have to be sanitized to the point of being boring. Sometimes the truth is upsetting, like the truth that tobacco use causes cancer and heart disease. And taken together with the first point, a graphic warning is not necessarily controversial simply because the image is disturbing. Any accurate illustration of someone suffering from cancer or cataracts is likely distressing, and that's a completely natural reaction and does not disqualify the warning. Finally, the Fifth Circuit opinion is another example of an appellate court recognizing that disclosures are not necessarily limited to preventing consumer deception. There are other legitimate governmental goals that can justify a compelled disclosure, like the goal of providing public health information. So if your jurisdiction is considering requiring some sort of warning label for tobacco products, including a graphic warning label, you still need to think about federal preemption. But above and beyond that, you should consider reading cases like this one very closely, because they'll give you guidance as to what is in bounds or not. And what you'll see if you read them is largely good news for public health advocates. There are still a lot of common sense limitations on what you can include in compelled disclosures, but the Fifth Circuit rejected industry's restrictive view of what the First Amendment requires and preserved government's ability to protect consumers through illustrated and impactful warning statements. So with that, if you have further questions about this, we'll open it up to Q&A, but we also have some information here as to how you can reach us, especially if you have specific TA requests, such as your jurisdiction considering pursuing a warning of this nature. So with that, I'm going to kick it back to Esther and we'll tackle any questions that you have. Thanks very much.
Thanks so much, Tom, for that informative presentation on this most recent case. We'll open up to questions. I saw one really good comment. I think you had a really nice turn of phrase there, Tom, so just accolades for that. I think also what we've seen from people is kind of just like general questions about, well, now that the Fifth Circuit has upheld this rule, what is next? What can we expect to come next? And so I know one of the questions that was submitted earlier was about when would the graphic warning labels go into effect? So it looks like now, because the Fifth Circuit has remanded this case back to the district level court, they'll have to go through, review it again, and basically take away the vacator that they put on the rule, which meant that they essentially nullified the rule. So once the rule goes back into effect, the FDA expects that because in the statute, it already has a 15-month delay, that once they get that mandate back that says the rule can go into effect, it'll probably be another 15 months. And then after that, there's like a 30-day kind of grace period to work with industry and other folks who may need that little more time. So it'll probably be about 16 months after that mandate comes back from the district court. Yes, Stephanie will type an answer back to that question for Mike. So that's just kind of what people can expect, I guess, as you're looking at this, as you're looking for those graphic warning labels to start to show up on cigarette packages. So it will be some time. But at least that means that the United States will start to join about 120 plus other countries that have already put graphic warning labels anywhere from about 30% of the package to greater than 75% of the package. And so that'll be at least good for the United States in moving in that direction. Tom and Luke, I guess a good question for you guys is the work that you've been doing in this space is, I guess, better understanding, do you think then that the applications in this Fifth Circuit case, what does that mean, I guess, for the wider tobacco industry and how they'll have to go about with warning labels moving forward?
Yeah, I can jump in on that. So I think if you are in a county, city, tribe, state who's considering enforcing your own sort of or creating your own warning, including a graphic warning, you still need to think about federal preemption. So there are federal laws that restrict whether and to what extent you can impact advertising or marketing for cigarettes and combustibles, different rules for other tobacco products. So that's one level. But from a constitutional perspective, I think this kind of opens the door to being able to explore more types of warnings than perhaps we were thinking about before. I think there was a concern that the circuits, when they weighed in on this, would create almost a per se rule that you cannot have illustrated warnings. And the Fifth Circuit, as I mentioned, being one of the more conservative circuits, there was a real concern that they would rule against the FDA. And since they didn't, I think that's really positive and optimistic news that this is a tool in the public health toolbox that's become available to us. And so I think it's something that jurisdictions can consider doing very carefully, obviously, as we mentioned, all the factors that go into a successful outer defense, but it's something they can consider, certainly.
Yeah, I think that's definitely good to know. We have a couple of questions kind of relating to that. I see there's one, have any other local jurisdictions passed a law requiring graphic warnings? I don't think so off the top of my head, but most likely if one did, I would imagine the industry would probably sue kind of under preemption grounds, saying that it's only the federal government that can. And considering that while we have a good order from the Fifth Circuit, it doesn't mean, well, we've also seen other circuits that have taken a different approach, but it doesn't mean that future circuits will take the same approach as the Fifth Circuit. So I think right now, it's, as you said earlier, it's, we're cautiously optimistic, and I think it's a good sense that we might be on good footing, but, we'll see what happens as the industry continues to pursue what it does. Yeah, and I think that also goes kind of similar for other public health warnings. In terms of, this question is about food and other FDA proposals. I mean, I think that'd be interesting to see how far this goes, if it's more than just tobacco products, if the FDA is looking at this for the Food, Drug, and Cosmetic Act as well. But I think that's definitely something to consider about what type of disclosures, in addition to what's already required for a lot of food and cosmetic products, that this could mean as well. There's a question about if there was something sent back on the FDA's violation of administrative law. I don't recall that piece being sent back, being remanded, but Tom or Luke, do you recall something on the Administrative Procedures Act?
Yeah, so I think what at the district court, the industry had moved for summary judgment on two grounds, one constitutional and one that the graphic warnings didn't satisfy the Administrative Procedure Act or the APA. The district court based its ruling on the constitutional question and did not reach or discuss the APA issue. So the Fifth Circuit, I believe, did remand for further consideration if necessary on the APA question. So there is a chance that we might end up in the same place with a district court of the Fifth Circuit saying that this is, you can't go forward with this rule, but it would be on administrative procedure grounds instead of constitutional grounds.
Yeah, so it's definitely true. Well, I think the last question we have was, can localities use this ruling to require warnings at point of sale? Again, I think that kind of goes back to our larger discussion of localities could potentially use this as a way to move forward with any warning labels that they want to do. But I think they would also just have to make sure that they're very careful, particularly when it comes to combustible cigarettes, that they are not in violation of federal preemption laws. And, if you have a specific case, definitely feel free to reach out to us. So on that note, I think we'll close out. We're at time. Thank you guys again for your participation. We really appreciate the questions. If you have further questions, or if you are in a jurisdiction or with a health advocacy group that's really interested in this topic, please feel free to reach out to us through our website and our email, and we will be sure to get back to you. Thanks again, everyone.